Okay. It appears we have everyone that we need on this case. Attorney Christensen, I believe you represent the appellant, and did you wish to reserve any time for rebuttal?
Yes, I would like to reserve 5 minutes for rebuttal, please.
Okay, and I will let you know as close as I can to that part without interrupting you too terribly bad. You may proceed.
Thank you, Your Honor. May it please the court, Jennifer Christensen of Lash and Goldberg on behalf of petitioner Dr. David Halperin. Dr. Halperin has filed a petition for cert based on the trial court's order denial of his motion or denying his motion to dismiss based on Florida statutory immunities for peer review and credentialing. In his response, Dr. Castellano only disputes the first criteria for certiorari relief, a departure from the essential requirements of law, and he concedes the other two criteria have been met. So that's what I'm going to focus on. There's been a departure from the essential requirements of law. First, the Florida statutes provide participants in a hospital's peer review and credentialing activities from immunity from suit. And that's exactly what's alleged to have occurred here. Dr. Castellano alleges in his amended complaint that he made a request pursuant to section 4.29 of the 2015 bylaws that he attached to his amended pleadings. And if you look at section 4.29, it's an individualized request for new privileges. He alleges in paragraphs 10 through 14 that Dr. Halperin was interviewed by the Credentials Committee regarding his request, and that his claims are based on Dr. Halperin's participation in the review of his request. So this is traditional credentialing and peer review activity for which Dr. Halperin is immune. The only exception—
Ms. Christensen,
yes,
we have to, you would agree we have to find that the trial court's action here was arbitrary, right? That no reasonable trial judge would have found the way that the court did here. And so I ask you, looking at the order, the trial court determined that there were factual disputes that needed to be resolved and that could not be resolved on the motion to dismiss. So how can we find that that's arbitrary?
it's arbitrary because if you look at the allegations in the complaint itself, and you look at the documents that were attached to the complaint, it contradicts that. The allegations in the complaint plead directly into Florida statutes 395-0191.
Well, they actually plead, they're actually pleading and saying, hey, none of this is within the immunity, right? Because of what was going on. So I actually think they actually plead the opposite. Go ahead.
That's a conclusory allegation that's actually contradicted both by the bulk of the other allegations in the complaint. And I'll walk you through the allegations that I think contradict any claim that this wasn't a credentialing or peer review action. And it's also contradicted directly by the 2015 bylaws they attached to the complaint itself. And so I think you can disregard a conclusory allegation that's contradicted both by the attachments to the complaint and the other allegations in the complaint itself.
And so let's say we do that. Okay, let's say we say this was within the realm of the credentialing process. And you've cited to the bylaws and the credentialing policy that talk about it. And certainly there was an investigation that was done by the credentialing committee. I guess the issue that I have is Dr. Halperin was interviewed, right, during that process, had the opportunity to say what he felt about it. But the letter, was it solicited or unsolicited to the committee?
So let me walk you through the allegations because I think that shows
Can
how
you answer
letter...
that question
Yes.
first? Okay.
I will. So he was interviewed by the Credentials Committee, and Section 4.29 specifically contemplates that information could be requested from one or more practitioners. And so his letter, to answer your question succinctly, the MEC and the board did not request that he send the letter, but I don't think that makes this letter any less part of that credentials process. And here's why. The letter is in direct response to his interview by the Credentials Committee. And in the letter itself, he says that he's trying to work within the framework of the medical staff. That's to quote directly. I want to stay within the framework of the medical staff. The framework in section 4.29 says the credentials committee reviews a request for new privileges, makes a recommendation to the MEC, which makes a recommendation to the board of trustees, which makes a final decision.
Isn't he really upset that the train appears to be leaving the station and everything's going forward and it's going to be approved? And so he's upset it's happening, and he's actually complaining about the process and that his words were not heard, and the liability that the hospital is going to take on. It isn't really that, and he's doing it on the eve of the hearing.
So what he's doing, I think is clear in the letter, is saying, I met with the credentials committee. They didn't agree with me. And now I'd like to speak with the MEC or the board. And I want to stay within the framework that's outlined in section 4.2. There's nothing in section 4.2 that wouldn't allow the board or the MEC to decide to hear from or to review information considered by the credentials committee. In fact, that would be only natural if the credentials committee is making a recommendation that the MEC or the board could look at that information. And what I think the letter asks is, I'd like to meet with the board and tell them my point of view. And that's all happening before the board makes a final decision under section 4.29.
You would agree with me, just because someone sends a letter that was unsolicited in the credentialing process, that letter doesn't necessarily get cloaked with immunity.
So I actually think that 395.0197 covers all and provides immunity for all actions that arise from or relate to. So I think an unsolicited letter would actually fall within the plain language of 395.01917. And I don't think this court can read that provision to exclude a letter that's sent directly to a medical staff review committee, which the credentials committee, MEC, and board of trustees are. This court held in Dadubai versus Belcito that the board of trustees is a medical review committee. You can't say that an unsolicited letter isn't arising from or relating to when the letter on its face directly references the new request for privileges under 4.29. So I believe that Florida Statutes 01917 is broad enough to include an unsolicited letter. I wouldn't characterize this letter as unsolicited because he was invited into the process. He was interviewed by the credentials committee. They reached out and asked for his input. And he asked,
did they tell him to provide them with additional information in the process? I mean, after they concluded their interview, did they ask for any other information from him?
That's not alleged in the complaint. And I don't think you need that level of detail to conclude that this is a classic credentialing or peer review action that would fall within. What he has alleged is that he was interviewed. And then he's attached to his complaint a letter that references plainly a request for new privileges under 4.29, and also references his desire, his knowledge that the credentials committee went against his advice and desire to continue to participate.
So what you're saying is that anytime someone is interviewed in a credentialing process and wants to complain about the process, that their words in complaining are immune.
I believe that the communications and deliberations of those committees are immune. And that would include folks.
But that wouldn't have been in the deliberation. That was a letter that came outside of the deliberations. That was for the purpose of changing the deliberations.
I believe anybody that submits a letter to those committees regarding the credentialing request is immune. Dr. Halpern is a member of the medical staff. He is not a stranger. He is a member of that medical staff. And under the bylaws, as a member of the medical staff, he has the right to petition the MEC and the credentials committee about any concern he may have related to credentialing and peer review. And those activities would be, to the extent he's petitioning the credentials committee and the MEC and the board of trustees, classic peer review and credentialing activity. Most peer reviews, most credentialing actions will be started by an individual petitioning a committee or reporting information to a committee. And all of those individuals, I believe, are protected under the plain language of the statutes. The statutes 395-0191 and 0193 would provide protection to any person. And so I'll give you a perfect example. If a nurse at the facility was concerned about safety and reported that to the peer review committee or the credentialing committee, we would view that, even though it's unsolicited, as clearly a peer review or credentialing activity that's protected, and there's no difference here. I believe that what makes it peer review and credentialing is that it was done pursuant to section 4.29 of the 2015 bylaws that are attached to the complaint that track directly to credentialing.
Let me ask you specifically with respect to subsection 8 of 395-0191. It talks about how this is at the end. However, information, documents, or records otherwise available from original sources, which in this case would have been from Dr. Halpern, are not to be construed as immune from discovery or use in any such civil action merely because they were presented during proceedings of such board. How am I supposed to apply that, if at all, in this case?
I don't believe that this letter would be considered an original source for the following reasons.
Well, who created the original source? You'd agree that Dr. Halpern was the originator of the letter.
Dr. Halpern drafted the letter, but he did so after being invited by the credentials committee to be part of a credentialing process and a peer review process to review an application or request for new privileges. So a request was made under section 4.29, and his letter is directed at that request. So it's part of that peer review process. This isn't an original source that deals.
I want to ask one question, because you cited in the brief a couple of sections of the bylaws. And what my question, there's a preliminary question. First, did Dr. Castellano actually apply for privileges in this new practice area, or was he simply asking the hospital to create a new practice area, and everyone recognized if it was created, he would apply? Is it the first or the second?
I will tell you that under these bylaws, if you look at section 4.29 that he attached and that he cites, or 4.26, there's an individualized request for new privileges. And so that is how the process is triggered. An individual makes an individualized request for new privileges. And then there's a decision.
Wait. But the sections of the bylaws that you cited to, one was 4.A.5.
Yes.
And the other one, if you give me a second, was, of course, now I might not be able to find it, but
4.2.9.
There we go.
Yeah, under the credentials, are you looking at the 2015 or the credentials?
I'm looking at the one you included in your appendix and to which you cited. And so both of those sections talk about determination of a change in clinical privileges and applications for a change for a particular physician.
Mm-hmm.
But it seems to me, and this is what my question is directed to, it seems to me that this is the proverbial cart before the horse, because Dr. Castellano could not apply or did not apply for an expansion or change as to the privileges that he had without a new practice area first being approved. So while he may have been the motivator behind it, and he may eventually apply for a change, that didn't happen yet. So the two bylaw sections that you relied on don't seem to be consistent with your argument that this is a peer review or clinical privilege review process.
So I would point you to 395-0191 subsection 4. And that outlines what is considered credentialing, including the creation of a delineation of privileges. So
for a specific person, correct?
If you look at subsection 5,
wait, am I correct?
Subsection 4, it does talk about for a specific person. And what I would say
Says
is
each
that
applicant.
the specific person here is the person requesting the new privilege. But even if
he's
you
not
don't
requesting a privilege, he's doing something preliminary to that. He's asking for the hospital to recognize and create a new specialization area. And if that happens, then he applies for privileges.
And that falls under 395-0191 subsection 5. which says the governing board of each licensed facility shall set standards and procedures to be applied by the licensed
Yeah.
facility and its medical staff in considering and acting upon applications for staff membership or clinical privileges.
And he
So the-
did not apply for staff membership or clinical privileges yet.
But he asked the hospital to set the standards and procedures to be applied if he ever did. And that's specifically contemplated in 395-0195.
I just want to make sure, I wanted to make sure I understood what the time sequence is. And it
Yes.
seems like I have it correct. He asked for the hospital to create a specialization area in the hope that if it was approved, he could then apply for privileges.
And I would submit to you, Your Honor,
As you begin your
that-
answer, I would let you know that we're past 15.
I would say that that second step is covered under 395-01915, that the statute is broad enough to include more than just an application for privileges. Under 5, it's the creation. And subsection 7 also provides immunity for actions arising out of or related to. So creating it arises out of or relating to.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Levine, you may begin.
Yes, Your Honor. If it pleases the court, Stuart Levine on behalf of the respondent, Dr. Castellano. And I know that pronunciations are important to Your Honor, and so I wanted to clarify for that, for the record for my client. So I have 3 key points I would like to make in response to the argument we've heard from the petitioner. And that is the first, the allegations of the amended complaint do not on its face implicate any of the immunity statutes. 2, the immunity statutes do not apply to a hospital's business decision to analyze the prospects of a new business area. And at the end of the day, this resolution by this court is basically a statutory interpretation. And so I would like to jump right into each of the statutes and explain why none of them apply to the facts of this amended complaint. And the lowest hanging fruit I'd like to point the court's attention to is 766.101, which is the Medical Review Committee Immunity from Liability, also known as the Medical Malpractice Statute, that petitioner has argued provides absolute immunity to the unsolicited unilateral letter that was sent after the completion of the process. And if we look at that statute, section 1 through section 1L identify setting up committees for the purposes of participating in medical malpractice review by various types of hospitals. They cite to chapter 641 type of healthcare facility, 395, which is our type of healthcare facility, 607, 617, 394, 397, 916, and so forth. But they all end with the following, and that is at the bottom under section L. It says, which committee, the committees I just identified, is formed to evaluate and improve the quality of healthcare rendered by providers of healthcare service, to determine that health services rendered were professionally indicated or performed in compliance with the applicable standard of care, or that the cost of healthcare rendered was considered reasonable by the providers of professional health services in the area. So the immunity applies to those committees which undertake that activity that I just described. And what's interesting, if you read further through the statute and you look at section 766.104, that's titled Medical Negligence Cases, Reasonable Investigation Required Before Filing. And in this section that Dr. Halpern is claiming immunity from, in paragraph 1, it says no action shall be filed for personal injury or wrongful death arising out of medical negligence, whether in tort or contract, unless the attorney filing the action has made a reasonable investigation as permitted by the circumstances to determine there are grounds for a good faith belief that there has been negligence in the care or treatment of the claimant. None of that is the subject matter of this amended complaint. And to beat the horse a little further on that subject matter, if you take a look at 766.106, this statute under which Dr. Halpern is claiming immunity sets up the procedures by which a lawyer and a plaintiff may sue a healthcare facility. They have to give pre-suit notice, pre-suit investigation, informal discovery, a certificate they couldn't get it resolved. And those are all the things that people involved in that process are immune from. So the medical malpractice statute 766 is wholly unrelated to any of the claims for alleged in the amended complaint. And I want to, if I may, and in addition, I think Judge Silberman, you pointed it out, and I think Judge Smith, you may have as well, that medical malpractice relates to individuals in general. So taking a look at two statutes, 395.0191 and 395.0193. I want to talk about them together for one moment. And the purpose I want to talk about them together for one moment is because they are narrow in application. They are not broad in application as the petitioner would have you believe. And if we look at the immunity section under each of those statutes, and they're the same paragraph and they have very similar language, paragraph 8, it says the investigations, proceedings, and records of the board or agent thereof with whom there is a specific written contract for the purposes of this section. So we start off with the proposition that 395.0191 and 395.0193 and the immunity granted by our legislature is limited to those activities taken pursuant to this section. So let's address, if we may, section 395.0191, which is titled Staff Membership and Clinical Privileges. It starts off by identifying the setting up of the ability for an individual to apply for staff privileges. It talks about how the entities are to have rules and procedures so everyone knows what's happening, so you know when your application has been accepted and why, or when it's been denied. And the Longwood Medical Center versus Desai case at page 1031 from the 4th District Court of Appeals calls this the appointment statute, because that's what it is. It applies, as Judge Silberman asked, after someone makes an application, after an individual makes an application for staff privileges, that's when 395.0191 becomes a statute which may provide immunity to those who are participating in that process. Similarly, in 395.0193, which is the peer review statute, again, if we look at paragraph 1, it is the intent of the legislature that good faith participants in the process of investigating and disciplining physicians pursuant to the state mandated peer review process shall, in addition to receiving immunity for retaliatory suits pursuant to 456.073, be protected from federal antitrust suits filed under the Sherman Act. Such intent is within the public policy of the state to secure the provision of quality medical services to the public. Each licensed facility, as a condition to licensure, shall provide peer review of physicians who deliver healthcare services at the facility. Each licensed facility shall develop written binding procedures by which such peer review shall be conducted. And then it goes on to describe the peer review. And then it has the same limiting language about when that immunity applies. Clearly, there's no allegation anywhere in the Second Amendment complaint that Dr. Halpern or Dr. Castellano or anyone else was subject to peer review at the time, at any time, much less at the time that Dr. Halpern sent his unilateral, unsolicited, defamatory letter to prevent his competitor, as alleged in the amended complaint, Dr. Castellano, from being able to have additional privileges that didn't exist. There, as Judge Silberman noted, there was no practice area called cosmetic surgery as alleged in the amended complaint. And the amended complaint only alleges that Dr. Castellano mentioned to one of his coworkers who happened to be on the medical executive committee, hey, have you guys considered a cosmetic surgery practice area? And that's when the process began of reviewing that possibility for the hospital. the petitioner has not cited a single case to this court which stands to the proposition that that a credentialing committee, anytime it does any work, is automatically immune from its activity. And petitioner certainly has not cited a case that says when a hospital assigns the responsibility for determining whether or not adding a practice area to the hospital would be good for healthcare or good for patient care or good economics, they cite no case which would stand for the proposition that all of a sudden the immunities afforded the credentialing community when they are credentialing a doctor in a hospital ipso facto applies to that process. So is there any questions that your honors have for me? All right. Thank you very much for your time. And I'm concluding by saying that the petition for certiorari should be dismissed or denied. Thank you.
Thank you, counsel. We will, the court will entertain rebuttal now. There's 4 minutes and 30 seconds remaining.
Thank you. I just want to hit a couple key points. First, under 395-0191 subsection 5, the governing board of each licensed facility shall set the standards and procedures to be applied by the licensed facility and its medical staff in considering and acting upon applications for staff membership or clinical privileges. That encompasses the obligation to create a delineation of privileges. So this statute is broad enough to include that conduct. In addition, subsection
Well, is it
7,
broad enough to include the conduct? If we start with section 1, in considering and acting upon an application for staff membership or clinical privileges, it appears it's the acting upon that this whole section deals with, and that section really is a ministerial duty saying you can have your own rules.
Section 7, which provides immunity, applies to any act arising to or relating to, and you can't have an application without a delineation first. And so they're part and parcel, and those two things are so interrelated, they can't be separated. And that's what the 4th DCA held in Berlin. So in Desai, the 4th DCA pointed to the language in subsection 7 that makes it clear immunity applies to acts arising from or related to. That would include lots of activity, not just applications themselves. Subsection 5
Well,
specifically
5 doesn't
requires,
section 5 say considering and acting upon applications?
for membership or clinical privileges, but in order to have an application, you have to have a delineation first. You got to have 1 + 2 makes 3, and so they're all interrelated. They arise.
If you have to have those first,
relate
that would presume
to.
they're already in existence. And you
Well-
wouldn't need an immunity for that. You would just need immunity if you're pursuing or under that.
I don't believe you can separate the two acts under this statute
Okay.
because
I understand the
subsection
argument.
7 makes
Gotcha.
it clear. And I think the 4th DCA in Berlin and in Desai recognized that the immunity, and there they applied immunity to pre-screening functions before there's an application. So I think to separate out those two functions parses the statute in a way that the legislature didn't intend. The legislature intended for physicians to participate effectively in peer review and credentialing. And if physicians are afraid that they'll be sued for participating, and here, I don't think the letter, to get back to your question of whether it's an original source would be a document that would be created in any event. For example, a medical record. This letter only exists because he was interviewed by the Credentials Committee. And it only exists because he followed up on his interview through the existing credentials process. That's the exact type of behavior that the Florida Supreme Court recognized in Holly versus Old would be protected and would be silenced if we allow physicians to be sued or their words to be used, words that were directed to a credentials committee for a credentialing matter related to whether or not to create privileges that was initiated by the request of an individual pursuant to the bylaws. All of that is conduct that falls squarely within 395-191. You don't need to parse between the delineations or the application. And I don't think 395-1917 suggests that you should. In fact, the legislature was concerned that you would be silencing effective peer review and credentialing. And that's what will happen, that physicians won't participate when they're asked by a credentials committee to weigh in because they don't want to be sued. And that's not what the Florida legislature intended. And it's not what the patients in Florida deserve.
You had a few moments left. Okay. I don't want to take
I
up your
would-
time.
I would direct.
You still
the
have a
court-
minute.
No, I mean, I still have, I will direct the court to the cases that I believe support our brief.
I was
And
looking at
those-
Judge Farmer's opinion out of the
Right.
fourth.
Feldman versus Bluecroft dealt specifically with a question of whether procedures fell within a delineation of privileges. There's Desai, there's Berlin, Daduvai versus Belzito, and Hockey. All of these cases and a broad group of cases spanning 30 years have recognized that this credentialing activity is protected. There's no basis to distinguish between things that the creation of a delineation of privileges or a request to create one from an application. It's a distinction without a meaning. And 395-0191 subsection 7 plainly says that immunity applies to any action arising out of or related to carrying out the provisions. That's very broad, and it would certainly include the creation of delineation of privileges, which is specifically required in subsection 101.5, subsection
Thank
5.
you. I will advise you that time has expired.
Thank
On
you.
behalf of the court, we thank you both for your presentation now this afternoon. And we wish you well, and please stay in good health. We hope to see you our next time. Maybe we have live and in person.
Yes, sir.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
We will move to the